Hello friends, this is Sumiti Ahuja. I am working as Assistant Professor with Amity Law School Noida, Amity University, Uttar Pradesh. To start with the learning outcomes, after completing this module, the reader will be able to understand in detail the various essentials for determination of liability under criminal mischief and aggravated forms of mischief. The reader will be able to articulate and discuss the statutory framework related to offence of mischief. The reader will be able to appraise the value of relevant case laws and illustrations in gaining in-depth understanding of the concepts. Before I proceed with the presentation, I'll briefly give you the contents of this module. I'll be starting with a brief introduction of the module, proceeding to offence of mischief as it has been dealt under the Indian Penal Code 1860, followed by aggravated forms of mischief under the IPC 1860, and at the end I'll be summarizing my presentation with a brief summary of the entire thing. To start with, introduction. Criminal mischief can be said to have come in existence since the time people started owning personal property, for it involves and includes any instance of a person damaging someone else's property without his permission. In general, it refers to any damage, alteration, defacement or destruction of tangible property with a criminal intent. The requirement of proving mischief is to show that the offender intended to cause wrongful loss to any person. Mischief has been placed under sections 425 to 440 of the IPC 1860, which include offences dealing with injury to the property. Now, section 425 throws light on the essentials of mischief, followed by section 426 prescribing punishment for the same. Sections 427 to 440 provide for 14 aggravated forms of mischief with varying degrees of punishment depending on the loss sustained or damage suffered, value of the property destroyed, mode of commission of mischief, utility of the subject, and probable consequences of the mischief. Now I'll proceed to the offence of mischief as it has been dealt with under the Indian Penal Code 1860. Now the essentials of mischief as laid down under section 425 IPC, which defines mischief, are: firstly, intention to cause or knowledge that he is likely to cause wrongful loss or damage to the public or to any person. Now this intention is the mens rea of this particular offence under the section 425. Second essential is causing destruction of some property or any change in the property or in the situation thereof. This constitutes the actus reus, and the change so made destroying or diminishing the value or utility or affecting it injuriously. Now, section 425 of the IPC is based on the principle enunciated in the maxim sic utre tuo ut alienum non liedus, which means use your own property so as not to injure your neighbors or anybody else's property. Now, no mischief can be committed where the acts complained of amount to an invasion of civil rights, as was laid down in the case of Salin Sardar versus the state. Now, essentials to determine the liability under this section. I'll be discussing them in detail. First is intention to cause or knowledge of likelihood. Now, the offence described imports the act done willfully or with knowledge that the said act is likely to cause loss or damage. Now, an act which harms or lessens the value of property if done by accident or mistake and not willfully does not make the doer an offender under the Indian Penal Code. Now, mere negligence also does not qualify to be covered under this section of mischief. The section contemplates some direct act on the part of the mischief doer, either personally or through someone else. Now, the term causes under the section implies some act done or some willful conduct, or a conduct which is done out of your own will. Now, second essential, if I discuss it in detail or elaborate it, that is wrongful loss or damage to the public or to any person. Now, wrongful loss has been defined under section 23 of the Indian Penal Code as loss by unlawful means of a property to a person which a person is legally entitled to. The express mention of damage in the section indicates that the purview of the offence of mischief is not intended to be confined only to cases of wrongful loss, but also includes all such cases of damages by unlawful means. Now, the term damage under this section should be of a nature serious enough to be worthy of notice. If it is slight and trivial, the general exception contained in section 95 of the IPC may be applicable, and thereby the offender will be able to take the defense and escape the liability. Now, for the offence of mischief, there must be destruction of property where no one has any proprietal right to the property, as in case of a wild animal or a bird or a fish or animal fere naturae. The killing of same does not come within the mischief of section 425 of IPC. Another essential to make out an offence of mischief is one has to cause or know that it is likely to cause wrongful loss or damage to public or to any person. Now, necessity or acting in good faith for the purpose of preventing or avoiding other greater harm to a person or property amounts to an exception to the offence of mischief. If I put forth an example here, say for example, A in a great fire pulls down houses in order to prevent the conflagration from spreading. Now, here he can take the defense of necessity and escape the liability under mischief. If I elaborate the third essential to this offence, that is destruction of any property. Now, A voluntarily burns a valuable security belonging to Z, intending to cause wrongful loss to Z. Now, here A has committed mischief by destroying the property of Z. The term or the word property as used under section 425 IPC refers to any tangible property, whether movable or immovable. Tangible means it is capable of being seen, capable of being felt. It should be some property which can be destroyed. Now, it does not include within its ambit any incorporeal or intangible property such as an easement which cannot be destroyed. Now, this section is not applicable to ownerless property. The value of the property also is immaterial. Now, fourth essential, that is change in any property or in the situation thereof as destroys or diminishes its value or utility or affects it injuriously. Now, it does not necessarily refer to a change in character, composition or form. It will suffice if something is done to the property contrary to its natural usage and serviceableness that destroys or diminishes its value or utility. Now, if I quote an example here, say for example, A introduces water into an ice house belonging to Z and thus causes the ice to melt, intending wrongful loss to Z. Now, here A has committed mischief by bringing a change in the property as has destroyed its utility. Now, if I quote one more example here, that is cutting of electricity supply or water supply constitutes such destructive change in the property as diminishes its value or utility. Now, I would like to highlight here explanations to section 425. To start with explanation 1 to section 425, which explains that it is not essential under section 425 IPC that the property interfered with should belong to the person injuriously affected. Now, to elaborate it, I will quote an example here. Say for example, A knowing that B's house is fully insured, he burns it. Now, here A may not cause or intend to cause any loss to B, but if he knows that he is likely to cause wrongful loss to the insurers of B's house, he has committed mischief. Now, coming to the explanation 2 to section 425, it explains two things. Firstly, a man may commit mischief on his own property, and secondly, affected property may belong to the person committing mischief and others jointly. Now, from here, I will be dealing with the aggravated forms of mischief under the Indian Penal Code. Aggravated forms of mischief can be classified under 7 major heads. Firstly, on the basis of amount of damage caused, which is given under section 427 of the IPC. Second head is mischief in regard to animals, that is given under or stated under sections 428 and 429. Moving ahead, mischief in regard to water supply and public works, that has been dealt with under sections 430 to 434 of the IPC. Then mischief by fire, which has been dealt with under sections 435 and 436. Then mischief in regard to decked vessels, dealt under 437 and 438. Second last is mischief in regard to any vessel with intent to steal, dealt with under section 439 of the IPC. Then under section 440, the aggravated form of mischief, which is mischief with preparation for causing death, hurt or wrongful restraint, or fear of such death, hurt or wrongful restraint. Now I will be throwing light on the different aggravated forms of mischief. To start with section 427, that is the deciding factor for defining any offence under this section is on the amount of the damage which has been caused. Now the only difference, this is an interesting fact, that the only difference between section 427 and the preceding section, that is section 426, is the extent of the damage which has been done. Now for establishing of charge under this section, the same essentials must be proved as for a charge under section 426, plus it must be further proved that the value of the property was of rupees 50 or upwards. I would like to cite a case here, that is Kashi Ben Chhaganbai Kohli versus State of Gujarat. That is a 2008 judgment of Supreme Court. Now in this judgment, the appellant, who was the original accused, that is Kashi Ben Chhaganbai Kohli, she was owner of an agricultural land which she had sold to this person who is the victim or the defendant here, the respondent here. Now in this case, what happened? This lady, she had accepted the earlier payment in the form of a check of rupees 40,000 from this person, later on accepting a further sum of 60,000. She had agreed to sell her land to him on the amount of rupees 1,45,000, of which the 1 lakh had already been paid, and she had drafted, or she had given a document signed by her which was in this person's name. Now after this person had taken the possession of this particular land, after few days she entered inside that particular land and tilled the land with tractor. Now this person, the victim here, he had already taken up one crop of sugarcane, and he was waiting for the regrowth of the other sugarcane crop which he wanted to sell further for money. Now before he could do that, this lady tilled the land and destructed the entire crops. She was held guilty under this section. Now I will be moving on to the next head of aggravated form, that is mischief in regard to animals, punished under sections 428 and 429. Now in order to secure conviction under section 428 of the IPC, the prosecution must prove that the accused committed mischief, that is defined under section 425, and that mischief was committed by killing or poisoning or maiming or rendering useless the animal in question, and the value of the said animal was rupees 10 or more but less than rupees 50 at the relevant time. Now section 428 is a general section dealing with animals. Those cases which do not fall under the ambit of section 429 will be covered by section 428 if the value of the animal in question is rupees 10 or upwards, but it does not exceed rupees 50. Now the punishment under section 428 IPC is imprisonment which may extend to 2 years or fine or both. Section 47 of the Indian Penal Code defines animal as any living creature other than a human being. Now, the animal destroyed here must be the subject of property. These sections are limited to domesticated animals only and they do not apply to wild animals. Here I would be elaborating the terms poisoning, maiming and rendering useless as have been used under this section. Now poisoning, to start with the term poisoning in itself is sufficient to bring the case within purview of sections 428 or 429. It isn't necessary that as a result of poisoning the animal be rendered useless or maimed. Now the term maiming. Maiming includes privation of use of limb or member and implies a permanent injury. Amputation of any member or injury of animal by which its speed or endurance or use is permanently diminished would also qualify for the term maiming. Now moving on to the term rendering useless, the term has to be differentiated from diminishing of utility. Now rendering temporary useless would not be sufficient enough to be covered under this section. Section 429 makes provision for two kinds of cases. Firstly, certain specified animals, namely elephant, camel, horse, mule, buffalo, bull, cow or ox, irrespective of their value. It will include specified animals of both genders as well as of any age. And any other animal, the second category is any other animal except for those mentioned above of the value of 50 rupees or more, which is covered under section 428. Now, the punishment under section 429 IPC is imprisonment which may extend to 5 years or fine or both. Now, moving on to the next head of the aggravated form of mischief, that is mischief in regard to water supply and public works, which is stated under sections 430 to 434. To start with section 430, which is titled as mischief by injury to works of irrigation or by wrongfully diverting water. It punishes those who commit mischief by doing any act which causes or which he knows to be likely to cause a diminution of the supply of water for agricultural purposes or for food or drink for human beings or for animals which are property or for cleanliness or for carrying on any manufacture. This particular offence is punished with either description for a term which may extend to 5 years or with fine or both. Proceeding to section 431, which deals with mischief by injury to public road, bridge, river or channel. This section punishes those who commit mischief by doing any act which renders or which he knows to be likely to render any public road, bridge, navigable river or navigable channel, natural or artificial, impassable or less safe for travelling or conveying property. Now this section is punished with, or the offence under this section is punished with a term which may extend to 5 years or with fine or both. Proceeding to section 432, which covers cases of mischief by causing inundation or obstruction to public drainage attended with damage. Now it punishes those who commit mischief by doing any act which causes or which he knows to be likely to cause an inundation or an obstruction to any public drainage attended with injury or damage. The punishment for the same is the imprisonment which can be extended to 5 years or fine or both. Now, section 433 covers cases of mischief by destroying, moving or rendering less useless a lighthouse or a sea mark. Now, it punishes those who commit mischief by destroying or moving any lighthouse or other light used as a sea mark or any sea mark or buoy or other thing placed as a guide for navigators or by any act which renders any such lighthouse, sea mark, buoy or other such thing as aforesaid less useless as a guide for navigators. This section or this offence is punished with a maximum imprisonment which can go up to 7 years or fine or both. Now, ending this particular head with section 434, which deals with mischief by destroying or moving, etc., a landmark which is fixed by public authorities. Now, it punishes those who commit mischief by destroying or moving any landmark which is fixed by the authority of a public servant, or by any act which renders such landmark less useful, or useless as such. Now, the punishment which is given under this offence is the punishment which may extend to imprisonment for 1 year or fine or both. Now, moving on to the next aggravated head of the offence of mischief, which has been dealt with under sections 435 and 436, that is mischief done by fire. Sections 435 and 436 are generally referred to as the offences of arson and cover instances when mischief is caused by fire or explosive substances, thereby causing damage to property. Now, while section 435 relates to destruction of property, which is more in the nature of movables, the section 435 relates to destruction of immovable property like building, temple, go down, etc. Now, section 435, if I start with, it provides for punishment in case of mischief by fire or explosive substance with an intent to cause damage to amount of 100, or in case of agricultural produce, 10 rupees. Now, punishment here is imprisonment for a term which may extend to 7 years and fine. Now, moving ahead to section 436, this section makes setting fire to a building which is used as a place of worship or for dwelling purposes or even for keeping custody of any property. Now, it is punished with an imprisonment for life, or it can be an imprisonment which can go up to 10 years and fine. Now, moving on to the next head of aggravated form of mischief, which is stated under sections 437 and 438, dealing with mischief in regard to decked vessels. Section 437 IPC reveals the intention of legislature to punish mischief committed on vessels which are likely to carry passengers. Section 438 of IPC is an extension to section 437. It provides more punishment because of the dangerous means used. So, now this is the differentiating part between the both. If we talk about the term vessel as used under these sections, the term vessel is defined under section 48 of the IPC, which is the word vessel denotes anything which is made for the conveyance by water of human beings or of property. Now, it will therefore include ship also. If I proceed with the essentials of section 437, I would like to say that the accused committed mischief, firstly, that the accused committed mischief against the vessel in question, same has been defined under section 425. Further, the said vessel was either decked or of a burden of 20 tons or upwards, and by mischief the accused intended to, or he knew it to be likely that it would thereby destroy it or render it unsafe. The punishment given is maximum imprisonment of 10 years and fine. Now, coming to the essentials of section 438, the accused committed, first is the accused committed or attempted to commit mischief by using fire or any explosive substance. It was committed or attempted to be committed to a decked vessel or an undecked vessel of a burden of 20 tons or upwards, and by mischief the accused intended to, or he knew it to be likely that he would thereby destroy the said vessel or render it unsafe. Now, the punishment given for this offence can be imprisonment for life or maximum imprisonment of 10 years and fine. Now, moving on to the next head, that is given under section 439 of the IPC and covers mischief in regard to any vessel with an intent to steal. Now, this section can be considered to be akin to piracy. Now, it is punished, therefore, it is punished with an imprisonment which may extend to maximum period of 10 years and fine. Now, to ensure conviction under this section, there are certain essentials which have to be proven by the prosecution, which are, firstly, the accused ran aground or ashore the vessel in question. Secondly, he did so with the intent to commit theft or dishonestly misappropriating property contained in the said vessel, or with the intent that such theft or misappropriation of property might be committed. Now moving on to the last aggravated version of the offence of mischief, which has been dealt with under section 440 of the IPC, that is mischief with preparation for causing death, hurt or wrongful restraint, or fear of such death, hurt or wrongful restraint. Now, in order to secure conviction under this section, the essentials to be proven are: firstly, the accused committed mischief as given under section 425, and the said mischief was committed after making a preparation for causing to the person in question death or hurt or wrongful restraint, or fear of death, of hurt or of wrongful restraint. Now the punishment prescribed for offence under this section can run up to a maximum imprisonment for 5 years and fine. Now at the end of this presentation, I'll briefly summarize the points which I had taken up, the important points which I had taken up in the entire presentation. To start with, offence of mischief is covered under sections 425 to 440 of the Indian Penal Code. Now these sections provide for definition of mischief, punishment for the same, and it is followed by 14 aggravated forms of it with varying degrees of punishment. Now the major requirement for proving mischief is to show that the offender intended to cause wrongful loss to any person in contrast to other offences against property. Wrongful loss has been defined under section 23 of the Indian Penal Code. The mens rea for mischief is that the accused intended to cause or had the knowledge that he is likely to cause wrongful loss or damage to the public or to any person. Now the actus after the mens rea, the actus reus lies in causing destruction of some property or change in the property or in situation thereof. Thereafter followed by 14 aggravated forms of it which have been classified under 7 major heads. I hereby end my presentation. Thank you all for watching this presentation. I hope it was fruitful enough for you. Thank you.